I am now going to dictate a recent judgment of the Calcutta High Court at a speed of 100 words per minute for shorthand transcription practice. Let's start. This appeal arises from the judgment and order passed by the learned single judge whereby the investigation into the criminal allegations against the appellant, Mr. Shahjan Sheikh, was directed to be handed over to the Central Bureau of Investigation (CBI). The appellant, a former leader of the Trinamool Congress from Sandeshkhali, is accused of serious offences including rape, extortion, and assault. The matter gained prominence following an alleged attack on an enforcement directorate (ED) team deployed to search his premises in connection with the ration scam pattern. The appellant contends that he was not made a party to the writ petition in which the impugned order was passed. He argues that he is both a necessary and proper party as the writ petition directly concerns the criminal case in which he is an accused. It is submitted that the impugned order adversely affects his legal rights and that the delay in filing the writ petition, given that the FIR dates back to 2019 and the charge sheet was filed in 2022, remains unexplained. The appellant alleges that the writ petition is politically motivated and amounts to a vendetta. Counsel for the appellant further submits that the High Court ought to have considered the principle of odi alteram partem and that the accused should have been heard before the investigation was transferred to the CBI. He argues that the right to a fair investigation includes the right to be heard on the choice of investigating agency para. On the other hand, counsel for the respondent argues that the appellant, being an accused, has no right to choose his investigating agency. The respondent asserts that the appellant is neither a necessary nor a proper party to the writ petition. It is submitted that the investigation conducted by the local police was perfunctory and that the gravity of the allegations warranted a probe by a specialized agency like the CBI. The learned single judge, having considered the nature of the allegations and the inadequacy of the local investigation, directed the CBI to take over the probe. The division bench finds no infirmity in the reasoning adopted by the single judge para. It is well settled that at the stage of investigation, the accused does not have a right to be heard. The principle of odi alteram partem is not superimposed at the pre-trial stage of criminal proceedings. The High Court is not obliged to hear the accused or make him a party to a writ petition seeking a direction for investigation by a particular agency. The appellant's contention that the delay in filing the writ petition renders it liable to be dismissed is also without merit. The delay, if any, does not vitiate the proceedings, especially when the allegations pertain to serious offences and the investigation by the local police is alleged to be compromised para. The court notes that the allegations against the appellant are grave and include acts of violence against public officials. The ED team was allegedly attacked while performing their official duties. Such conduct, if proven, strikes at the very root of the rule of law and warrants a thorough and impartial investigation panel. The court also observes that the appellant's challenge is premature, the investigation is yet to be completed, and the appellant will have ample opportunity to defend himself during trial. The transfer of investigation to the CBI does not prejudice the appellant's right to a fair trial. Stop para. The Calcutta High Court reiterates that the accused has no right to interfere in the choice of investigating agency. The principle of natural justice does not mandate a hearing at the stage of investigation. The court emphasizes the need for impartiality and thoroughness in cases involving serious criminal allegations. Accordingly, the appeal stands dismissed. Stop. Thank you.